Hi, everyone. So I'm Rachel Hirsch. I'm going to explain to you what today's panel is actually about. So this was supposed to be the panel for today. Unfortunately, my co-presenters had emergencies which prevented them from being here today. So I am going to give you a little bit of a different topic, and I hope you'll stay and entertain me for the hour. I promise you it'll be informative, and I promise you it'll hopefully be a little funny. Not because I don't know what I'm talking about, but because I'm trying to be funny. And we're going to, I will leave cards for later on. There will not be a PowerPoint since this was literally impromptu last minute, but I've spoken on the show many times, and if you haven't heard me before, hopefully this will be a good idea of what I do. I've had a last-minute panelist join me who did not have an emergency and was able to join. This is Ben Grossman. I'm going to introduce myself quickly and then let Ben introduce himself. And then I will tell you, I'll hold you, you can wait in suspense as to what we are going to talk about. And we're going to really try to make this.
We're still trying to decide.
No, that's not true. We're going to try to make this as interactive as possible. So this is your time to come ask a lawyer a question without getting charged for it. So take me up on my offer, and hopefully we'll make this as informative as possible. So I'm Rachel Hirsch. I'm a partner at the law firm of Ifrah Law. We are a DC-based law firm. We practice nationally. I'll get to the last screen eventually that has my contact info on it. And we help companies in this space with compliance and litigation matters. So we are very well versed on what certain agencies look for when they scrutinize a company, one such being the FTC. And so we help companies on a day-to-day basis control their processes and audit their compliance programs to make sure they are staying out of the crosshairs of agencies like the FTC, state AGs, and such. And of course, we are litigators, so we have a strong sense of what it takes to get into trouble. And we try to keep our clients out of trouble. Of course, we have those people who come to us when they get into trouble and not before, and that's a different story and one we'll talk about. So that's me. Go ahead, Ben.
My name is Ben Grossman. I'm the co-founder and CEO of Pinpoint Intelligence. We deal with high-risk merchant processing and chargeback mitigation. I used to be an advertiser. I've been to the show for many, many years for all different types of issues, such as getting traffic or getting new clients. So we're here today, obviously, to work with our clients and keep them compliant. And one thing that we've noticed, and the reason that Rachel and I seem to end up on multiple panels together, is the law and chargeback mitigation and preventing fraud really comes in and plays hand in hand very often. And it's actually the fraud and the chargebacks that very, very often is the red flag that gets our clients into trouble. So we're going to talk a little bit more about that as we announce our topic.
Okay, so this is actually a topic that I was thinking of doing as on a larger scale webinar that was going to be very exclusive. So you get the exclusive scoop of what I was going to do. It's basically the anatomy of an FTC case. And I'm going to tell you from an insider's perspective what happens when you get into trouble. We talk a lot about what happens about ways to stay out of trouble, but what people forget and want to really know is how do these agencies work? What happens if I'm sued by one of these agencies? What is my life going to look like afterwards? What is my life going to look like during a case? And so I have right now 5 active matters that I'm handling against the FTC, and I've experienced a broad range of cases with them, and I can speak from experience, from an insider's point of view, to tell you what leads to these cases and how to navigate them if you are being sued by an agency like the FTC. So for anyone here, does anyone here not know who the FTC is? Okay, good. That would be very embarrassing if you didn't raise your hand with that question.
Without a show of hands, how many of you have had conversations willingly or unwillingly with the FTC? No, don't raise your hand.
Well, Jason's in-house counsel, so
Jason's okay.
Jason's okay, so he can admit it.
He can admit it.
So the FTC is a Federal Trade Commission. Obviously, they govern marketing to consumers, advertising and marketing practices to consumers. So they are a name that's well known in this industry because they are governing the kind of message you put out there about whatever product you are selling through whatever means of communication. So Ben deals a lot with high-risk merchants. High-risk merchants are, do you want to define what a high-risk merchant is?
Well, the true definition is one that's going to have a higher chargeback ratio or higher risk to the bank itself. The way things have progressed over the last few years, it seems to be anyone advertising in a direct way online. Meaning if you're just selling a pack of gum online, you're probably okay. But once you're starting to push traffic, especially through affiliates, the risk goes up, and that's then viewed as a high-risk merchant. High risk is not just financial, because we have plenty of clients that fall into the high-risk category, that the actual financial risk is very, very low. They don't have a high chargeback ratio, so to speak, but what they do have is a high risk in regards to regulation, and that is what is the trigger that makes the banks nervous. So there's many different products out there that people are selling that the banks don't want to get involved in. So there's a big CBD oil, something that everybody's talking about. There's very few domestic banks willing to get involved in that because of the reputational and legal risks that go with that. So that's really where high risk becomes defined.
Yeah, so traditionally high risk used to be, if you think of traditional like adult gaming, real money gaming, it's kind of evolved into areas where people are processing high volumes every month. There's an increased rate of chargebacks. So I'm sure you're going to meet some of these folks if you're not one of them. These people in the industry who are doing in the Nutra space, in the skin space, in the trial space. Anytime you have someone who is billing continuously a client, you're going to have a risk of chargeback, because either the customer is going to say, hey, I didn't know you were billing me every month. Hey, I don't like your product. It didn't do what you said it was going to do. And so those become the kind of gray area for chargebacks, because you're dealing with disclosures to consumers, and just do consumers understand what you're selling them, how you're selling it to them, and what you're charging. And so we've seen a lot of cases that have been brought by the FTC in these kind of high-risk areas. And traditionally, everyone asks me, how do you get in trouble with the FTC? Well, there's many ways. One is you're making a whole lot of money doing something that seems like you shouldn't be making that kind of money, right? You're making $100 million in dealing with consumer transactions, and you're selling, I don't know, I'll choose an example, Garcinia Cambogia, and telling people they're going to lose 40 pounds in 40 days. Well, to the FTC, that's going to seem suspect. Why are you making so much money on a product that probably does not do what you claim it's going to do? Definitely not lose 40 pounds in 40 days without exercise and diet by just taking a nutraceutical supplement. And so they typically want to go after the deeper pockets, someone who is going to have the types of assets that they can come and collect to then redress consumer loss. Now, the way the FTC defines consumer loss is kind of strange, and one I actually do not agree with. Consumer loss is not just the people who lost money buying your product. I mean, you may have 100,000 customers. Let's say 90,000 of them are happy and 10,000 of them are unhappy or dissatisfied, and they charge back, and then you have to Pinpoint has to take care of it for its client. That seems like, well, that's not so many. Out of 100,000 people, 90,000 were happy. The way consumer loss is defined by the FTC is that even if you had 90,000 happy people, the consumer loss is the full 100,000, meaning you are liable to redress that full 100,000. So really, it seems unfair and inequitable. Why am I redressing people who never ask for refunds? Why am I redressing people who never charge back their purchases? And they were happy and I never heard from them. Well, because if the FTC says one part of your company is fraudulent, the fraud spreads and taints the rest of your company. And so then you're liable for not just what you profited, because you personally may have profited maybe $3 million, right? But if you had $100 million in transactions, they're going to make you redress the whole thing. So there are those extreme cases where the FTC comes in without you knowing, in the dark of night. They seize all your assets. They appoint something called a receiver, and you can't access your bank accounts. You can't use your credit cards. They do this through a method called ex parte, which means without your participation. They file something in court. They get a judge to sign off. They show the judge the evidence they have against you. The judge signs off an order. That order is then served on the banks, and all of a sudden, you can't use your bank accounts anymore. And all of a sudden, you're in the office, and the receiver, this guy called a receiver, comes in, and he wants access to all your computers, access to all your paperwork, all your documents. You have to stop working, and your company is effectively shut down. That's called an asset freeze case. Those are the most extreme cases you'll see from the FTC, because they involve, you have no access anymore to your money. So it begs the question, how the heck am I supposed to defend against a case when I have no money to pay for it?
Well, the other aspect of that, Rachel, is that not only do you not have access to your money, but now you can't even service the clients that may be disappointed or they like your product because now you can no longer ship your product because your vendors are not going to continue to ship out the product if you can't have access to your money. You're not going to be able to refund because you don't have access to your merchant processing accounts. So even the consumers that are upset are now going to become more upset, and you get into this spiral that is pretty awful as well. So you need to hire a lawyer, and you've got to take care of your current business in order to not let things snowball. So what do you do?
So what do you do? Business is shut down. No one's working with you. You can't work. You can't access your customer files. You can't talk to customers. You can have contact. You get served with what's called a temporary restraining order, a TRO, and in it outlines your obligations. Your obligations are you can't transfer assets. You can't encumber any assets. You can't sometimes use corporate or personal credit cards, which begs the question: how am I supposed to live? So some people are forward thinking, and what they try to do is enter into these asset protection plans, these offshore accounts where they have a trustee set up. It's not really theirs, it's somebody else's, and they have money saved for a rainy day. Sometimes that works. Sometimes courts, as part of an FTC case, you need to disclose your finances. The very first thing, your obligation that you have to do within 5 days of getting your TRO is fill out a personal financial disclosure form and a corporate form to the extent that applies to you. And you need to list all of your assets, all of your spouse's assets as well, even if they have nothing to do with your business. And you have to list any bank accounts or any trust that you have an interest in. So I don't personally do asset protection because that's a very unique area that some lawyers and non-lawyers do. But there are companies and lawyers who set up these offshore trusts in a way where they don't actually put in the person's name. They're not actually a beneficiary. So they feel like they can get around the disclosure requirement, and they don't have to actually tell people that they own or have a benefit or can receive money from this trust. Sometimes that works, but oftentimes it doesn't. In some circuits, the offshore trust, like the Ninth Circuit, California falls in the Ninth Circuit, Nevada falls in the Ninth Circuit. There's some bad case law that says you need to what's called repatriate those funds. Even if you have funds in bank accounts outside of the U.S., the TRO requires that you bring those funds back in the U.S. And if you do not comply, you will be held in contempt of court. And so they have mechanisms to enforce these provisions against you. So there are some asset protection lawyers who will tell you that they've set it up in certain ways, and I don't know the particulars of what they do, but a lot of courts frown upon these offshore trusts and will still make you repatriate.
So in regards to the cash that's going into those, obviously most of them are coming through your merchant processing. So the first question that everyone asks me when they're trying to get new accounts is, oh, do you have anything offshore? Because they feel like it's just a safe haven. Once they're offshore, everything's good, everything's allowed. What's been proven time and time again through case law and through situations that we've all been involved in or exposed to is that doesn't work. And actually, the FTC has certain jurisdiction or some way, I don't know the law side of it, Rachel can explain that more, but somehow they're able to find out and track down those funds as well, depending, obviously, on how it's set up and how it's structured and I guess where you get in trouble.
Well, if you have offshore merchant processing, if there's wires going back and forth, they already got subpoenas out to your banks. They've seen all those wires go back and forth. They know you have these accounts. And it's your duty to self-disclose as well and to say what accounts you have. Because even if they don't know it right away, they're going to find out at some point through further subpoenas. So if you lie to them, it's not going to be pretty for you, and you will be held in contempt of court.
Right, and if you're selling the U.S., you're bound to U.S. rules and regulations when you're selling to U.S. customers, even if you're not processing that transaction in a U.S. bank.
That's right. Even if you're not in the U.S. yourself and you're dealing with U.S. customers, you are subject to the FTC's jurisdiction. There's some question, actually, if you are in the U.S., but your entire business is outside of the U.S., whether you are subject to the FTC's jurisdiction. I have had conversations with various FTC offices to see where they fall on that, because the only thing that's the nexus in the U.S. is that person being physically located in the U.S. No customers in the U.S., no bank accounts in the U.S., no actual operations other than you and sitting in front of your computer in the U.S. I think that's still something that's debatable, and I think I don't think the FTC's jurisdiction should reach extraterritorially in that situation, but that's still something that's up for grabs. So going back to the point where people feel like, well, I'm offshore, I'm safe, that's not always the case. So they've come in, they've seized your assets. You have 5 days to 3 days to comply, 5 days to comply with certain things. You have to serve the copy of your TRO on all your partners, all your employees, anyone you've ever done business with. And that's not to say they've maybe by that time they've already put out a press release calling you a scam artist. I mean, if anyone's ever seen an FTC press release, they all look the same. They all lived a lavish lifestyle, and they scammed all these consumers. It's all the same words. I tell clients, just don't take it personally, because everyone is a scam artist. So you're basically guilty until proven innocent, and that rarely happens. You're basically just guilty the entire time. So that's kind of how the standard of how the FTC works. They love to use the keywords lavish lifestyle. Those are the famous words. I had a case where we were asking for fees and living expenses in this case, and they said, well, they hired this fancy DC law firm. Why should we pay for that? So I'm like, well, thank you. I didn't know how fancy we were, but suffice it to say, we got fees in that case. But they have the same response in every case. So you come in to ask your fees case, and you have your TRO. The next thing that happens is you're scheduled for what's called a preliminary injunction hearing. The TRO is temporary. It's only for a short amount of time. The judge signed the order for it to last for, let's say, 5 days, 10 days. By then, at the end of those 10 days, you have to have what's called a preliminary injunction in place, or the TRO expires. A preliminary injunction is basically the same thing as a TRO, but it extends throughout the duration of the case. So, yeah, go ahead. It's a temporary restraining order. It restrains you from doing something until you can have a hearing, okay? So they set it for a certain amount of time. Some judges will say this is good for 7 days, and you have to have your, I'll call it a PI hearing, your preliminary injunction hearing by the end of the 7 days. Otherwise, come back to me again and get a new order. But typically, you'll have your hearing. You'll either agree to, some people may push it off a little bit because they need time to prepare. But that is your first and best and sometimes only opportunity to get your narrative before the court. If you lose at a PI hearing, it's not good for the rest of your case, and I'll tell you why. At the PI hearing, for the FTC to prevail, for them to get a preliminary injunction for the duration of the case, which extends the asset freeze, which makes your temporary receiver into a permanent receiver. Does anyone know what a receiver is? A receiver is someone who comes in, it's like a bankruptcy trustee, right? They take over your entire business. They are now effectively the business, okay? So you have no control over the business anymore. They may close down the business if they think it can't operate legally. They may continue running it if they think they can collect some money that's owed to the business. Typically, it's the death toll for your business. It means your business is no longer going to operate. There's no way it's going to be revived, okay? If this temporary receiver becomes a permanent receiver through the preliminary injunction, that's what it effectively means for your company. So what they have to prove, the FTC, among other things, is likelihood of success of the merits. They have to convince the judge to extend the TRO into a PI because they think they're going to prevail on the merits of the case. They're going to prevail on the claims they're bringing. The typical claims they bring is under the Section 5 of the FTC Act, which prohibits unfair and deceptive marketing practices. It's a very broad statute. It could be anything that seems unfair, deceptive, create some sort of material misrepresentation that customers rely on. So it can mean any vertical, any kind of product, any kind of communication. So that's the typical jurisdictional hook that they get. It's Section 5 of the FTC Act. Sometimes they'll have other statutes along with that, but that's what you're going to typically see in an FTC case. And they're going to say, Judge, we need a PI because we can prove that we're going to win at the end of the day. Look at all their pages. Look how many disclosures are missing from their pages. Look how many consumer complaints we've gotten. By the way, this may be the first time ever you see some of these consumer complaints. Most people think, hey, look, my BBB rating is great. I've only had 2 consumers complain, or I only ever got 2 or 3 AG letters. When you get your TRO, or when you get those papers, you're going to see hundreds, sometimes thousands of complaints that you've never seen, never heard of, and you don't even know where they came from. And those complaints are typically sent to the FTC directly through what's called the FTC Sentinel database. They're not shared publicly with the company. The company will never have heard of these complaints before, and they just accumulate against you and are used as evidence against you in a TRO. So if they prove likelihood of success in the merits, that they can succeed, it's basically telling the judge, hey, we just have to see this case out until we get to the end, and we're going to win. So if you lose at that PI hearing, that's what is critical to come in armed with evidence. And what people forget the most is about PI hearings is you don't want to rush into it within the 5 days. Sometimes you can ask for an extension, but you also don't want to extend it for too long. Because what happens is, I had a case where I took over the firm that handled it before me, thought that they could negotiate with the FTC. In the meantime, they pushed off the hearing for 4 months. So by the time they filed their papers in opposition, the FTC came back with reply papers with all new evidence. that they couldn't overcome. Why? Because they already had access to all their office, their computers, their CRM, their documents. They were able to use all the stuff they got after they got the receiver in place as further evidence against the company. So you want to do it very quickly, but you also want to be prepared. Typically, in like a Nutra case or something, it's going to be very hard to show that it's going to be very hard to beat this likelihood of success of the merits.
We're talking about things with the complaints that we've seen have been font sizes not being large enough,
right.
The dollar amount not clearly stated in close enough proximity to where they put the credit card in and accept the terms and conditions, the button not being the right size, shape, connected to the right words. The sky's the limit to the imagination of what could be harming consumers and how consumers can be harmed as a result of the way you've set up your landing page and your checkout page. And some of it is even to the point of ridiculous, like even your flashing lights. You're going to be charged. Well, the font size on the flashing lights wasn't big enough. So it's super, super broad, and it's hard to even anticipate what you can do. But what could we, is there more anticipation that they could be doing? Is there compliant, like, they would be working more on compliance, but even within compliance, how far does it go to protect you?
So the way the FTC works is they try to use previous cases as precedent for establishing guidelines for new cases. So when they settle or get a judgment against one company, they'll say, look, the order will specify, how they have to behave in the future, if they are even allowed to market, let's say, continuity again in the future. And so every company after them will have to look at that order and say, well, if they're required to do this, that's what the FTC is going to expect of us as well. Well, the thing that's unfair about that standard is, and we'll get to this toward the end, is typically companies settle FTC cases. That's what happens. People settle because the standards are just too hard to overcome. The case law is so unfavorable for defendants. And so they're pressured into settling, and they have to basically agree to what the FTC wants them to agree to. And that somehow becomes a standard for other people who are not in these high-pressured situations to accept these standards. So yeah, compliance is a big part, but like you said, sometimes the placement of a checkbox can be something that triggers a consumer complaint.
I have a question. You talked about landing pages. What do you recommend we put on landing pages? Positions, the text size, maybe the policy, the privacy policy, font size, location, that kind of stuff.
So I'm just going to repeat the question because you're not mic'd. The question was, what can we put on landing pages to help from a compliance standpoint? So that's a really broad question, and one that I probably have addressed in some other situations. It's going to be very dependent on the case, but I'll give you an example. When you're dealing with what's called a negative option offer, right, where they're going to get billed unless they call to cancel. That's called a negative option, okay? They require that you disclose that fact before the person has made a purchasing decision. That means before your order page. The minute you say trial, whatever you have to say, you have to clearly disclose that this person is going to be charged on a continuous basis. So a lot of people forget that step. They just wait to the sales page. Then they have links to their terms or privacy policies. Not links that anyone actually ever has to read, right? It's just the link is there and you say, by agreeing to this, you've read our terms. Well, the FTC does not like links because a link distracts the viewer from the natural progression of the page. It's something you have to click and it takes you to something else. And so they don't want your terms buried in links, right? They also don't know that customers are actually going to ever read those terms because you don't have a checkbox. There's no pop-up that appears if they don't check it. You can't scroll through it and read it and then confirm that you got it. And sometimes people have those links below the submit button, right, which defeats the purpose because they've already submitted their purchase and now they're seeing the terms. So those are the common mistakes you'll see in a kind of rebuild trial space of where disclosures need to be placed. They'll forget the checkbox. They'll have it pre-marked, pre-checked. Those are all big no-nos when it comes to the FTC, especially when you're rebilling customers. Yeah. By the way, thank you so much for indulging us and asking us questions on this new topic. Yeah, no, by all means, keep going.
So let's say the FTC does come at you and you lose the case, everything goes downhill afterwards. Let's say my company is now looked at as bad by the FTC or my name. What do you do? Like, let's say I really want that checkbox this way, or the terms here instead, because of course it's advantageous to have it the way you want it as opposed to the way they want it. But do they now flag my name or my company?
So the question becomes, so this is great. We're jumping ahead to what happens at the end of the case. I don't need to go in any progression. We can talk.
Let's say I'm flagged by the FTC. So that they're
So the question is, what happens if I settle with the FTC, my company settles, I resolve the case, and my name is on it, and I don't want to follow the protocols that they've now imposed on me because I think the checkbox should actually be somewhere else. What happens to me, right? And what happens? So,
Well, I think the first question he really has is my picture now on the desk of the FTC? Do I get my picture hung up there like next to others?
no, so this is, I'm going to jump ahead to what happens when you settle an FTC case or you get a judgment. When you settle, typically you have reporting requirements for 20 years, okay? Typically, that's like the most long. You have to report to them. They impose, first of all, sometimes in the most egregious cases, you're banned from ever doing that kind of marketing again. So there's a permanent ban. So yeah, you can never do that kind of marketing again. In some cases, they'll do carve-outs, but the carve-outs will be very specific. You can market continuity again if you have a checkbox like this, if you have a disclosure like this. I mean, they're very stringent, right? And so you have to abide because even if the case is over, the judge, the court, still has jurisdiction over that case through the consent order because you have reporting requirements. And the FTC does monitor what you are doing. Your picture may not be on a wanted ad in the FTC's offices, but they know who you are. I'll give you another example of how I know that that's the case. And then this is kind of jumping ahead, but this is a free-flowing kind of conversation. Most cases with the FTC, how do you redress the $100 million consumer loss? I don't have $100 million, right? So they look at your assets that you disclose in your personal financials. They figure out what it is you have that you could put towards settlement. And they do what's called a suspended judgment on an ability to pay basis, meaning you are liable for $100 million, but let's say you only have $3 million of assets. We'll suspend $97 million of that judgment, and you turn over $3 million, based on your sworn financial statement. If at any time we find out you are lying about your assets, we have the right to open up what's called the avalanche clause, where you will be liable for the full $100 million. And if you think that doesn't happen, in the last year in the Northern District of Illinois, they reopened a case because a guy did what I'm going to tell you should never do. And if you read the fee front article that I wrote this month, you should read it. It's in your bags. He did not exercise common sense. And what did he do? He flaunted on Facebook or social media his cars, his house. And they said, wait a second, where did this come from, right? And they reopened the case, and then he was liable for the full amount of the judgment. Now, in that case, it wasn't $100 million. I think it was in the hundreds of thousands. But either way, they found out he was not telling the truth, and he had sworn to it, in his financial statement that he disclosed everything, and they reopened the case, and then he was liable for everything. So they do monitor. Often it's people's stupidity that gets in the way, and, right, I said this in the article, and one of the questions I had, one of the things I said is, I've seen a lot of people. I had a case where this guy got a subpoena, and he's very worried about whether they would come after him, and I said the first thing I did was check his Facebook page, which was public, by the way. And he was standing next to every fancy car you can think of. So I called him up. I said, dude, what's with the cars? First of all, you look like a you-know-what. Starts with a D, ends with a oosh. And then second, I mean, if anyone's looking at your pages, they're going to think, this guy has a ton of money. So if you ever want to settle with anyone, they're not going to believe you don't have anything because you're standing next to every fancy car in the world. So he agreed. He says he's a born-again Catholic. It's fine. He's not going to do it anymore. Don't have a public Facebook page, by the way, if you're going to do that. Don't go, flaunting your wealth publicly in places that people can see, and just exercise common sense. Because when you get a TRO, Exhibit A of the TRO is going to be, look at this guy. He's living this lavish lifestyle, right? And they're going to pull these links. They're going to go on your LinkedIn page. They always do. They're going to go on your Facebook pages. They're going to pull the information off these pages. Yes? Well, if they're going to sue you and they're going to come in ex parte, you're not going to know that they're coming. So you're not going to have seen a subpoena.
My point being is even if you're private, you're probably not doing all that shit privately. You're probably not helping yourself very much.
Yeah, just don't do it. I don't want to give away the ending of the fee front article. It's pretty funny. I wrote, the biggest thing the FTC hates is if you drive a Porsche or Ferrari, you're for sure getting sued. I don't care what you did. They just don't like you driving a better car than they have. So you should just drive a Honda, okay? That's my advice to every client I have. Like, what kind of car you drive? Oh, yes, you're for sure getting in trouble. Like, even if you haven't done anything wrong, every case I've had has included some sort of luxury vehicle, and they've had to turn that over. Why? A, because they can't make the payments anymore, or B, they have to turn it over as part of a settlement. And so, not to say that people who drive fancy cars are going to get in trouble, but, if you are bragging about it in a way that the public is going to see. It's not going to, it's going to look like you're flaunting consumer losses in the consumer's faces. Look how I deceived you, I took your money, and I spent it on my own lifestyle. And that's how they'll spend it.
So one thing I could just tell you, and we'll take questions after this. Most of the people we see get in trouble, and we've been doing this for a while. I've been around the block on all sides, like I said before, is be smart. Common sense is just like 90% of it. If I understand making landing pages aggressive, I promise you I know what aggressive landing pages are, and I've been there, and I've been worried about making that 0.5% or 1% conversion lift, which is like the gold. But guess what? Being smart is often a lot less expensive than losing out on some of your traffic. And just focused on the end goal and not on today is something that we've seen a lot of our clients, when they make those adjustments, they stay out of trouble, they're able to process, they're able to make plenty of money, and really have nice, good businesses that last long term. When they're trying to squeeze every penny out of every transaction and every conversion, and they're really upping their game and getting more and more aggressive, that's when they usually end up getting in trouble. Yes, they're making more money, but do you really want to give all your money over to your attorneys, or do you want to keep your money in your pocket? Now, obviously, Rachel wants you to give her all the money.
No, it's not true.
But
it's a good example.
As a business owner, I don't want to give my money to my attorneys as much as possible, and I spend plenty of money on attorneys to protect myself. And a lot has to do with compliance, and so much just has to do with don't be stupid.
It's true. I mean, the biggest complaints we see is consumers not getting their refunds. I always tell a client, give the guy the $16 back the first time he calls rather than pay me $500 an hour or whatever my rate will be at the time to write you an AG letter. It's just not worth it, okay? Don't try to keep upsell. I mean, listen, upsell is the name of the game. Major companies do it, right? When you call Comcast and you want to cancel your subscription, they're like, well, we'll give you a better deal. We'll give you this. It's just how it works. The reason Comcast doesn't get in trouble, and you do, is because Comcast is a huge corporation with lobbying dollars behind it, and Nutra is not. So, I mean, they're selling a product that people actually want and need, and sometimes, unfortunately, folks in this industry are pushing products that are not always what they tout them to be. And so they don't have those kind of lobbying dollars behind them, those energy. And so, while yes, it is standard business practice to upsell and try to retain a customer, sometimes it's just not worth the fight. Just give them the $16 back and move on. No questions asked.
One thing that I get in a lot of trouble with my clients with is I always ask them to have a different descriptor on each of their merchant accounts than they do on their website. Anyone want to guess why? Anyone? Because when someone...
He has the answer. Go ahead.
So when
he
someone...
said you see a different bill.
He said you see a... No, the reason is when someone calls in off their billing, they're already pissed. So why are you trying to save them, refund them, downsell them, upsell them, move them around? Just give them their money back. When someone's coming in from any of the other phone numbers that you might have that's not on your billing descriptor, try what you want to do in order to try to rescue that customer. But if they're calling off their bill, they're already pissed. So why are you trying to save them? All you're doing is getting yourself either a chargeback or a love letter from an AG, and worst case scenario, a love letter from the FTC, which
you
is
typically don't
never
get love
exciting.
letters from the FTC. Sometimes you'll get a CID, a civil investigatory demand. Those are the fortunate ones, because once they come to give you that, they're not going to go ahead and freeze your assets behind your back because you know it's coming. But you're not always going to get that love letter. It's going to be sometimes you wake up, your accounts are frozen, your office is raided by the FTC. Sometimes the FBI will accompany the FTC. That is a sign of a criminal investigation. Someone called me once and said, I want to hire you. The FTC came to my offices. They came with the FBI, but they said that's standard. I said, I don't know of any. I don't know that the FTC recruits the FBI to come to your office unless you're also being criminally investigated. And I can tell you there are a lot of cases out there now where there are referrals to the DOJ. I think the DOJ has become a lot more aggressive. Even in the rebill space, there are cases now out of New York. There's at least 2 that I know of where I spoke to a prosecutor in one case. I said, why are you bringing this case? I don't understand. It's an FTC case. And she said to me, it's because we do not think the FTC is a sufficient deterrent anymore, and we are taking over. It's also because they can't prosecute Wall Street, so they have nothing better to do in Southern District of New York than bring cases against Nutra guys or whoever they're bringing at the time. But that's what she said. Those are the words that came out of her mouth, which means there's, you got to be on heightened alert. So, I mean, these are the realities of what happened. So, yeah, you are, going back to your question, you are going to be monitored. You are, it's going to follow you around. People do recover, though, after FTC cases, okay? The one thing, if I could retitle what this was supposed to be, if this was the actual planned speech, it's a marathon and not a sprint. The first thing I tell clients is, this is going to last a while, and I need you to have the energy to see it through to the end. These cases go on for a year and a half, sometimes longer, depending on how intricate and complex the facts are. And they will settle with you when they are ready to settle with you, okay? So you've lost the PI hearing, let's say. The best thing you can do, by the way, just to go out back to the PI hearing, is if you don't think you're going to beat them on the merits, challenge them on the scope of the freeze. Sometimes the FTC will come in and seize all of your assets. Let's say this is a diet case, but you're also running a separate offer that is not diet. You're running a, I don't know, what's a good company? Credit Repair. I don't know. I'm going to throw that in there. Okay, Credit Repair has its own issues, but let's just say you have a separate company, but the complaint's about diet. You come in and say, hey, judge, they bamboozled you. When they made you sign this TRO, they didn't tell you that you were going to be seizing all my companies. This thing's way too overbroad. And sometimes judges will get upset that they were misled. I've sat there in this, I won't say who the judge was. He was amazing. He dissolved the receivership. He dissolved the TRO. He did not enter it because he felt misled by the FTC as to the scope of what the freeze was. So getting that carve out is going to be so important, because if you can get businesses up and running, you can pay your lawyers and you can live and you can defend your case. Otherwise, you're in a position where you're borrowing from family and friends, your lawyer's filing some sort of living expenses and fees application, which sometimes wins, sometimes do not, a lot of times do not. Courts are not sympathetic. They say you should go get a job, you should work, and you should pay off your lawyers. So the PI is over, and now you're like, okay, let me just get through discovery, get through settlement. The way these cases work is they work on parallel tracks. There's a litigation track and a settlement track, and those trains are both running at the same time. One does not slow down for the other unless you have settled and signed papers. When you have signed papers, they will stay the litigation track. But even if you want to settle, this track is still moving forward, meaning they're asking discovery, they're taking depositions. So you can't just say, I'm only in settlement mode, I don't want to defend the case. Because what's going to happen is this track's going to be going, and you're going to be so focused on this that you're going to get to the end of the case when they have to file their what's called their summary judgment papers, and you're going to have zero defenses and zero litigation leverage to try to get to a settlement. And settlements these days are looking pretty harsh. I can tell you, a lot of people I know who are in Florida think that their houses are protected because of homestead. Well, yes, the homestead laws are very strong in Florida. There's been recent case law and a recent case where the FTC actually got homestead because they're able to pierce through homestead through what's called a fraudulent transfer. If they can directly trace the money that went into purchasing that home to the fraudulent activity, then there have been courts and there have been cases in which the FTC was able to get that property as part of a judgment or even a settlement. And it doesn't matter at the end of the day whether or not they will win on a homestead. If they think they can get it, that's what they're going to demand of you in settlement. So sometimes settlement means turning over your house, turning over your cars, being left with very little. Sometimes maybe your life insurance policy, maybe a college savings plans for your kids, maybe an old car that you have. I mean, people have to rebuild, but they do. And I've seen people come out the other end, and this is just something that they have to get through. Hopefully there's no referrals to criminal agencies, and the case is purely a civil one. And we've seen people, if you know, in this industry who have gone through these cases and come out and restarted. And so it's not the end of the world, but it's pretty heinous while you're going through it. For a civil case to be subject to so much scrutiny and asset seizures and have to, basically you're fighting to maintain your life, living off family and friends. It's not a fun procedure.
So I guess basically to sum it up is don't be stupid and don't use Facebook.
Exactly. Well, no. Well, those are all good things. But I think if I can give a lesson from litigation is don't think that you're going to go into it just settling a case, right? That is the end of the goal. Most of these cases settle. Why? Because people have run out of steam, run out of money, or they just can't win because the case law is so favorable when it comes to the FTC. At the end of a case, when you've gone through discovery, you've taken depositions, they file what's called summary judgment papers. Summary judgment is a mechanism where you go to the court and say, Judge, you need to enter judgment in our favor because There is no dispute of fact in this case that these people did what we're saying they did. All you have to base it on is the law. So they'll go through the deposition testimony. They'll go through your discovery responses and say, look, you admitted X, Y, and Z. There's no dispute that you did this, this, and this. So because these facts are met and they meet the standard that we have to show to prove liability, we should get judgment in our favor. If you're at that point where they've actually filed briefs, it's looking pretty grim, okay? The key is to try to settle with them beforehand. The more work the FTC has to do on a case, the less likely they are to settle with you, and the offer's not going to look as good. I've seen cases where 3 months prior to summary judgment, the offer was, yes, you get to keep this, and then as they had to file papers, the offer just got worse and worse and worse. And what happens if there is a parallel criminal case? Well, if you get a judgment entered against you, even if it's a civil case, it's a judgment of liability, right? The criminal authorities can use that as evidence in their case. I mean, they have a higher standard of proof. They have reasonable doubt. In civil cases, it's just a preponderance of evidence. But you don't want some judgment out there saying that you did what you were accused of doing. When you settle with the FTC, it's on what's called a no admit, no deny basis. You're not admitting the truth of the allegations and you're not denying it, meaning it can't really be held against you in a further proceeding. So that's why settlement is favorable to most defendants, because they don't want that judgment out there.
So
And
I had a guy that I knew that had a major FTC case against him. They wanted something like $60–70 million, and he said, no, I'm going to fight them all the way. Well, he's somewhere about $2.5–3 million into paying his attorney, and they got it settled for another $3 million. He said, no, I'm going to keep fighting. He kept going, and finally ended up settling at $10 million because he just couldn't afford to keep fighting anymore, and he ran out of energy and steam. So be smart, and if you are in the unfortunate circumstance, take obviously the advice of your counsel, but don't think you're going to win and beat the FTC. Chances are you won't.
It's usually a matter of pride where I see people who don't want to settle. They feel like, but I didn't do anything wrong. And that may be true for a lot of people, that the standards are too high. But because the case law is just so disfavorable to defendants, it's not, the battle is just not going to be won. And so, they're forced into settlement. And, once they've done it, they feel better about it. But getting them to that point where they can accept that this is the reality of their situation is very, very hard to do. Especially someone who's been successful for a very long period of time, who really had good intentions, whose employees like them. We see that all the time. These are not bad people. These are all good, normal people that you'll meet on the street. It seems like a black mark on their lives that this is happening. But again, it's really just a civil case. It's not a criminal matter. And even in criminal cases, I've seen clients come out. You see these white-collar camps they go to. Often they're making deals in those camps, The one guy meets the other guy. Oh, yeah, what are you in for? I mean, I've seen people come out on top even after going to jail. So it's, there is recovery, but you have to be smart, and you have to try to settle with as little exposure as possible. I've settled cases where they haven't even taken depositions of our clients, and we were able to settle. That's rare because the FTC has its checklist of things that they have to do before they settle a case. But it can happen. And so it's just really being smart. And also, the one thing I'll tell you, if God forbid you're ever in this situation, is make that receiver your best friend. Cooperate with him on every turn, because he could be your best friend or your worst enemy. And let me tell you, it's much easier if he thinks you're being cooperative. If you're not, because the receiver, by the way, is appointed by the court. He or she does not work for the FTC. So you could settle an FTC case, and then the receiver can then file a separate case against you. They'll file what's called a fraudulent transfer case. So you may have saved an asset in an FTC litigation. The receiver can come after that asset if they think that this asset was paid through a fraudulent transfer. What that means is the company that they have now taken over paid for this asset without any consideration paid back to it. And that's what a fraudulent transfer is. I've had cases where the receiver has made these kind of demands while we're in settlement talks, and then once we settle with the FTC, the receiver will say, I'm going to back off too. I've also seen the opposite, where we've settled FTC cases, and then the receiver brings its own separate actions. So you're fighting now on two separate fronts. But it's really important to be cooperative and forthright, and it'll mean the end of your business, and you're not going to be able to revive that business, but whatever you can do to get out there unscathed, you should do that.
So anybody have questions?
Yes, go ahead. I'm going to...
So if you have an issue where, let's say you're an authority, you have a blog, you're an authority on something, and then you recommend something to your followers, and then
So the question was, what if you're a blogger, or I'll call it influencer, right, who recommends a product to consumers and the consumer doesn't like that product? Can they come after you for making that recommendation? Well, there's certain disclosure requirements when it comes to bloggers and influencers that you have to disclose that you are being paid, you're getting some sort of benefit for having recommended this product. We've seen a lot of letters go out to the FTC to these C-list celebrities lately who tout, flat tummy tea or whatever else you see on their Instagram profiles, where they have to actually disclose that's an ad, that they're getting paid. There was actually a case, it was not an FTC case, but that where the Kardashians were promoting some sort of diet loss product, and they did get sued because, it was for false advertising because they were promoting that product as an influencer blogger. So you do see that, but that's why in those cases disclosures are so important, and couching it as your opinion and not, if you don't say that you're getting paid to say this, or that you have what your affiliation is with the actual product, it's oftentimes where you'll get wrapped into it for not having done so. Does that answer the question?
Anyone else?
So what the question is, what if someone's advertising for you and advertised incorrectly? So let's say an affiliate, right? Okay, so at the end of the day, the advertiser, the person who owns the product, is ultimately liable for whatever is disseminated about his or her product. So you can certainly put controls in place and monitor what your affiliates or publishers are doing. There's always going to be that case of that rogue affiliate, right? The person who goes off stream and does something after you've told them not to. I mean, that may not prevent you from getting named in a lawsuit or an investigation or whatever it may be, but that's definitely a mitigating factor that'll get you out much faster, right? If you can show, if you have documentation that shows these are the policies we have in place, this is how we enforce the policies, we told them not to do it, the minute we found out, we terminated, that's always going to be the best proof, the best paper trail for why you shouldn't be held accountable for that.
A legitimate advertiser will have a process and procedure on how they deal with their affiliates.
And not just on paper, by the way. It's one they actually implement.
They implement it, and it'll be written out, and it'll be company policy. And when and if a case comes up and your employees are questioned, they're going to say, yeah, well, of course we do this. This is the policy, and they actually do it. So you'd benefit yourself if you're not doing it now and you're an advertiser to sit down with someone and get more information about what you should be looking for, what you should be asking, making sure that's documented, and making sure you're implementing it. You're not going to lose good traffic. I promise you won't lose good traffic for trying to get rid of the bad guys that are sending traffic that's garbage. You will have much better traffic if you're on top of your affiliates and you know what they're sending you and you're watching how they're sending it to you.
Yeah, go ahead.
I apologize to let off with this minute or two. Let's say I'm an advertiser and I've got 2-3 products. One product's more of what I would call a standard product, some kind of cosmetic, like that. I put my pages together the same way, market them the same way. I run my compliance to make sure I'm doing all the not stupid stuff that you want me to do. Is it fair to assume that the FTC is going to be more likely to come after me for the neutral product than are there certain product categories that the FTC is more aggressive on?
So the question is, I'm an advertiser, I have 2 or 3 products. One is a standard product, like a cosmetics line. Another one's Nutra, but I market them in the same way. Is it more or less likely the FTC will go after like the Nutra product? Typically, they're going to go after the products that get the most complaints, right? So it doesn't have to be Nutra. I mean, you're typically not going to see a lipstick getting, I'm selling you a lipstick if it's a straight sale, let's say.
Yeah, we're doing that option.
Right. So if it's a negative option, that's always going to be an issue. I mean, you could be selling teeth whitener, and that could be an issue, right? So it's not necessarily the product; it's sometimes how you market it.
Your refund policy and your advertising.
So the one thing I meant to mention, the way they loop in all of your companies is through an allegation called common enterprise, right? All these companies should be part of this case because they're run by the same people, they have the same accounting, they have the same offices, right? So you're running out of Tampa or wherever you are, you have all the offices, they're all run by the same person on the merchant account. So they're going to say they're all a common enterprise. Whether it's true or not, they could be different product lines. You could have different flow of funds from one product to another. You could keep bank accounts separate. Because the same person controls them, they come in and say, that's all we need to show, right? All we need to say is common enterprise. And that's their favorite terminology, by the way, is to say common enterprise. Right. So actually, that's a great point. I had a case, and unfortunately, I filed a motion that didn't end up seeing the light of day once it was filed because the client, for whatever reason, decided to pull it, where we challenged that. We said, that you're alleging a fraud complaint. You need to say specifically what each company did that was fraudulent. I mean, there's a heightened standard when you allege fraud. Somehow the FTC gets around that with common enterprise. But common enterprise itself sounds in fraud. Why? Because it allows you to pierce the corporate veil because there's fraudulent activity around it. So you have to allege specificity. I mean, this is an issue I would love for a court to take up and actually rule on at some point, but that's how they seem to get around everything, and it shouldn't really be their fallback position. Like, we don't have to. All we have to allege is this, and every company is encompassed with that, whether that company did exactly what the other companies did or not. That's one of the things you should be challenging at a PI hearing, right? People are so often focused on what the allegations are as the companies that actually did the wrong thing. They forget about carving out the companies that really shouldn't be included. So yeah, that's how they typically get people. So are they going to go after the Nutra versus your cosmetics? They probably will go after all of it, frankly, and you have to do the work. The burden becomes on you to prove that it's separate.
So if I have Nutra in my portfolio mix, really where I'm bringing in the additional risk is that people are going to be pissed off at the product and they're like,
The question is, if I have Nutra in my portfolio mids, right? That people are going to get pissed off about the product. Yeah, I mean.
And so that kind of a customer is more likely to complain. And that's what the risk is, right? So it's not like the FTC is targeting this, but they're probably going to hear about it more if people don't like that product.
Right. So he's saying that So I'm just going to summarize in the answer what you said because it was a little bit of a long question. I want to make sure I repeat it. Okay. The FTC protects vulnerable populations of the world, right? The overweight, the unemployed, the ugly, I don't know, whatever you want, whatever a vulnerable population is, the financially impaired, right? So if your product is targeting one of those vulnerable populations, it's more likely that those people are going to complain, right? And so, if you were selling something that everyone needed or wanted, right? And it affects all kinds of populations, it's less likely that you're going to get in trouble for those kind of things. But when you're targeting people who are financially strapped or elderly or the youth, those are areas of the population that the FTC really cares about. So yes, there are going to be more people who complain, especially if they're looking for a quick fix, which Nutra sometimes thinks provides or says it provides, right?
So we got about 5 more minutes. Is there any other questions?
Go ahead.
Do we have any other people that want to ask questions in the back?
Talron, come on. No.
You good? Yeah, what's your question?
So I know you specified earlier that we don't talk about traffic, but do you have any tips on traffic in general, specifically like finding good traffic sources that are quality versus like bots? I don't know. I'm new.
The question is, how do you find good traffic sources?
Yeah, so
go ahead, Ben.
I could kind of address this. What I do and what I did when I was an advertiser and what I do better now than when I was an advertiser because I have more time to concentrate on it, not running my own traffic anymore, is rate my traffic. The way we do it in our company in particular is that we score that traffic in real time based on 300 data points, based on chargeback ratios, based on the number of voids, refunds, where that traffic's coming from, and then looking long term and how many rebills are coming out of that traffic. And we're actually scoring it on 3 levels. We're scoring the PID, SID, and CID so that we are able to tell who's sending us good traffic and who's sending us bad traffic. When I was running my offer, it took us about somewhere between a week and a half to 2 weeks to be able to tell that. My clients can now see it in about 10 transactions, which is very cool. And turning off bad traffic makes you nervous because you're going to be hurting your conversion ratio, and then you're going to start to not sleep at night because you're worried about all that. I can tell you that the people who turn off their bad traffic, they have a lot of benefits. 1 is they sleep better at night. 2 is they actually get more traffic because they're able to pay more. Because if you think about it, let's say you're selling a Nutra product at $99. And that turns into a chargeback. That's another $40. And you're paying back the $99. Then you're paying the $59 out to your traffic sources. So all in all, that's costing you a pretty heavy amount of money, right? But if I take a couple less conversions because I've turned off, and by the way, the ones that are usually the bad ones are the ones sending you the least amount of traffic at the bottom of the totem pole. So it gets exaggerated, but it's really not that much traffic. you actually can pay more for your traffic. And what I did when we were running our penny auction site was we outpaid all of our competitors, and that's one of the reasons we were able to get as much traffic as we did, because we turned off the fraud. So it's scary at first, you lose a little sleep, but long term, everything's a lot better. You're getting cleaner traffic. Cleaner traffic generally has not only less chargebacks, less consumer complaints, less AG complaints, less FTC complaints, and life is just a lot better when you're running cleaner. We have literally less than a minute.
Yeah. Actually, you know what? I'm sorry. They're giving me the time signal. So I'm going to.
We've got to stop.
Yeah, we'll be around. I want to thank everyone for letting us do this panel today. And I hope you found it interesting and informative. And I'm sorry if you felt you missed out on the other panel. I was going to put my contact information up, but I realized I had other people's that are not relevant because they're not on the panel right now. They are relevant people, but not to this panel. So I'm going to, if anyone wants any cards, I'm going to leave them up front here. And again, thank you for staying. I know some people left, but we really appreciate you indulging us today. Thank you.